The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone here today for a hearing on intellectual property litigation and the U.S. International Trade Commission. And I will note that we will work as expeditiously as possible, but we may have a short break during a first round of votes later this morning. I'll now recognize myself for an opening statement. Today we are examining the U.S. International Trade Commission, a forum of adjudication of, among things, intellectual property cases. We want to focus on how IP litigation at the ITC fits into the overall IP system of the United States. IP-related issues raised by the ITC docket and recent developments relevant to the ITC and IP litigation. That's a complex way of saying that, in fact, after the eBay decision, the ITC has clearly become a place for the equivalent of injunctive relief, also known as exclusion. First, I want to thank the Ways and Means Full Committee Chairman, Jason Smith, and Trade Subcommittee Chairman, Adrian Smith, for graciously working with the committee so that we could hold this hearing. Although this is not a joint meeting, a joint hearing, there will be questions asked today specifically that were brought to us by the Ways and Means Committee, the Committee of Jurisdiction over the ITC. The ITC's mission, and I will repeat this many times throughout the day, is vital. The ability to enforce on behalf of American businesses and consumers is a role the ITC was formed for and needs to continue doing. The ITC focuses on investigating unfair trade practices, and IP infringement is essential for maintaining the integrity of our market. Clearly, there are times when the ITC uniquely has the ability to act quickly and to stop the importation of counterfeit or unfair competition, including patent-infringing goods. For example, upon finding infringement, the ITC can grant exclusion orders, and they do so quickly with only limited exemptions for granting them, and they do so because the companies or the individuals are usually outside the United States, and anything but an exclusion order would be ineffective. However, recently there has been a growing chorus of voices suggesting that the ITC is being misused for purposes other than its intent. Some stakeholders argue the ITC IP litigation system is being leveraged in ways that may distort the broader IP system. That's why the goal of today's hearing is to elevate the ITC's role and effectiveness in the overall landscape. We understand that the ITC's impact on IP litigation and enforcement is vital for ensuring the system remains balanced and effective. We must ensure the ITC continues to serve its role to maintain fairness, innovation, and competitiveness. This hearing is an opportunity to delve into those areas. And I want to reiterate, the ITC, in the opinion of the chair, for a very long time, has from time to time been misused. In my own home district, Qualcomm versus Broadcom, two multi-billion-dollar leading corporations, found themselves before the ITC. Why? Because it was a convenient venue. Would Broadcom support the idea that the ITC should have had some limitations? Yes, except it benefited them. Would Qualcomm support that the ITC needs to be limited? Yes, except when it benefits them. That is exactly why Congress must act. Corporations, large and small, want to see the best use of the ITC and, in the opinion of the chair, a 100% retention of their authority over companies or individuals that are outside the financial reach of the United States. And with that, I yield to the ranking member for his opening statement.
Thank you, Mr. Chairman. And The International Trade Commission was established as an executive agency by Congress in 1916 to oversee the importation of goods from around the world. Over 100 years later, it continues to protect the U.S. economy, our workers, and our innovators. But few know that the ITC has been around even longer than that. The agency we know today is the culmination of a series of legislative efforts that began at our nation's founding. Our forefathers understood, as we do today, that while the importation of goods from overseas can strengthen our financial position on the world stage and enhance our access to innovations around the world, the wrong products can cause grievous harm to our streams of commerce. American laborers, manufacturing hubs, and intellectual property owners all have a vested interest in ensuring that when products are imported from overseas, the company doing so respects the laws of our nation. This means that our country also has a vested interest in importing products that do not violate patents, U.S. patents, trademarks, and copyright laws, products that have not been produced in violation of U.S. human rights laws, and products that do not unduly interfere with vital American manufacturing sectors. The ITC is the designated venue for weighing such alleged violations, and while our colleagues on Ways and Means have jurisdiction over the ITC and its dealings, we on House Judiciary have a particular interest in the proper functioning of the agency's adjudications because of its impact on intellectual property cases relevant to this subcommittee's work. Under Section 337 of the Tariff Act of 1930, the United States, through the ITC, is permitted to investigate and exclude imported goods that infringe on U.S. intellectual property rights. Unlike in district court, the ITC does not issue damages. Instead, it is required to take into consideration public interest factors to determine whether to issue a remedy such as an exclusion order. These factors include the impact of the importation of public health and welfare, competition in the U.S. economy, production of competitive articles in the U.S., and the best interests of American consumers. Today, I expect to hear some of my colleagues argue that the differences between patent litigation in the district courts and the ITC mean that the latter is unfair, that we need to change how the ITC does business, and that various shadowy figures are using the ITC to take advantage of the system and U.S. businesses. I respectfully disagree. At its core, a patent right is the right to exclude, making the ITC a particularly efficient means by which to enforce the fundamental purpose of a patent. Between exorbitant costs, procedural hurdles, and long wait times, it has become difficult for a small business owner to hold and enforce a patent here in the United States. It is unsurprising to me that the same folks who say our patent system is doing just fine as is would also like to rein in the ability of the ITC to take and decide patent disputes. But what we must remember is that the ITC is a separate system designed for a different purpose. The ITC only issues trade remedies. It doesn't issue determinations of validity, offer injunctive relief, and is only available to a smaller segment of the patent-owning population. Section 337 investigations are designed to reach determinations quickly because businesses on both sides of the disagreement have an interest in speedy resolution to determine whether a product can be imported into the United States. On the specific topic of remedies, exclusion orders are narrower than injunctions in district courts and limited to the importation of infringing products from overseas. Some argue that patent owners are going to the ITC for relief because it has become the only way to prohibit a company from making an infringing product available while a district court is ongoing, a district court case is ongoing. I agree that patent owners should not be forced to resort to the limited ITC remedies to solve issues in our patent litigation. That's why I'm looking forward to joining Congresswoman Dean later this year when she introduces a bill to restore the availability of preliminary injunctions to patent litigants. I want to thank Chairman Issa for his ongoing commitment to bipartisanship, even when at times we disagree on policy. This subcommittee's ability to hold serious hearings that delve into complicated topics is unmatched, and I'm grateful to have Chairman Issa as a partner across the aisle. Thank you also to our witnesses for being here today, and I look forward to hearing your testimony, and I yield back the balance of my time.
I thank the gentleman. Without objection, all other opening statements will be included in the record. I'd now like to introduce our witnesses. Ms. Tara Hairston is the Senior Director for Technology Policy at the Alliance for Automotive Innovation, where she works on technology innovation, artificial intelligence, cybersecurity, intellectual property rights protection, and other issues. She previously served 5 years as the head of government relation at Kaspersky and spent nearly a decade working on federal and state policies at Honda Corporation. Mr. Sam Corti is the Senior Principal Counselor for Intellectual Property at the Garmin International Corporation, where he works on global intellectual property issues such as portfolio management, inbound and outbound patent licensing, patent prosecution, patent litigation, and prior to joining Garmin, he was an attorney in private practice where he focused on intellectual property law. We also have Professor Jorge Contreras. Mr. Contreras is the James T. Jensen Endowed Professor for Transactional Law and the Director of Program on Intellectual Property and Technology Law at the University of Utah. Professor Contreras teaches and researches in the area of intellectual property, property law, technical standardization, antitrust, and science policy. Professor Michael Doan is the visiting assistant professor of law at the University of Akron of Law. Before he taught full-time as a professor, he served as general counsel to Kent Displays and was the intellectual property attorney in private practice. We welcome all of our witnesses and thank them for appearing here today. We will begin by asking you to rise to take a swearing-in oath. Please raise your right hands. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and correct to the best of your knowledge, information, and belief, so help you God? Thank you. Let the record reflect that all witnesses answered in the affirmative. As is the policy, and we've probably all seen it on C-SPAN, your entire written statements and intended oral statements be placed in the record. We would only ask that you try to limit yourself on or very close to 5 minutes so that we have time for a round of questioning, notwithstanding votes that are inevitably going to take us away. I now recognize Ms. Hairston for her opening remarks.
Chairman Issa, Ranking Member Johnson, distinguished members of the subcommittee. My name is Tara Hairston. I'm Senior Director, Technology Policy at the Alliance for Automotive Innovation, which represents the automakers producing most of the vehicles sold in the United States and other players within the automotive ecosystem. Thank you for the opportunity to testify at this hearing to share the auto industry's perspective on intellectual property rights complaints and the U.S. International Trade Commission. Let me say at the outset, the auto industry knows the value of intellectual property rights to innovation. As significant rights holders, auto companies support robust legal protections for intellectual property rights. However, the auto industry today faces frequent and costly lawsuits alleging intellectual property rights infringement, many of which are filed by non-practicing entities making spurious assertions. This is happening more and more frequently, and it is a real problem. Auto companies want to ensure that intellectual property rights are properly granted and not being used for anti-competitive purposes. My full written testimony expands on the following essential points. First, auto companies support the ITC Section 337 investigative authority. Second, Section 337 disputes involving auto companies has evolved in recent years. Third, the auto industry is increasingly concerned about the use of Section 337 by non-practicing entities, or NPEs. And fourth, the auto industry supports ITC reform. The auto industry agrees with and supports the intent of Section 337 to protect domestic industry from unfair foreign competition. Auto companies have filed their own Section 337 complaints at the ITC when imported products infringe their intellectual property rights and/or when there was unfair competition. Auto companies have also been the targets of Section 337 investigations, including those involving abusive claims by NPEs. Historically, Section 337 auto disputes dealt with importing mechanical and electromechanical articles, but now they involve technologies like semiconductors, microelectronics, and artificial intelligence. These modern technologies have led to a major increase in the number of patents in the automotive space, which in turn has resulted in more patent infringement lawsuits targeting auto companies, both in district court and at the ITC. At the same time, auto companies are incorporating more technologies that are not unique to the industry into their products, which also expands the number of patented technologies on which ITC complaints can be filed. A significant number of these cases have been brought by NPEs. NPEs regularly bring Section 337 complaints to the ITC, often with the intent to gain unfair leverage against an auto company and force a company to settle pending litigation in another venue. They often succeed. The possibility that the ITC will issue an exclusion order makes the ITC an appealing venue for this purpose. This activity diverts important automotive resources from innovation and manufacturing to expensive litigation and settlements. Complaints filed by NPEs at the ITC frequently relate to small dollar parts within a vehicle. A potential violation of one patent could result in an import ban on an entire vehicle. Shared platforms across a single automaker or shared suppliers with components to multiple automakers could result in the exclusion of multiple vehicles. Since the primary enforcement remedy available to the ITC is an exclusion order that applies to the entire vehicle, auto companies are frequently forced into settling even when the merits of the complaint are weak. These exclusion orders hurt manufacturers, suppliers, customers, and overall competition by reducing consumer choice, discouraging innovation, and increasing costs for companies compared with others in the marketplace. This is why ITC reform is necessary, so that the ITC can focus on its mission of protecting domestic industry, and so it is no longer misused by NPEs to harm manufacturers, workers, and consumers. The automotive industry supports the following reforms. Strengthen the domestic industry requirement to focus on production-based licensing, not revenue-based licensing. Reinforce consideration of the public interest throughout a Section 337 investigation. Identify potentially dispositive issues that should be decided by ALJs within 100 days of instituting an investigation. Limit the issuance of exclusion orders when an allegedly infringing component is less than or equal to 10% of the overall product, and mandate disclosure of real parties and interests by complainants and respondents. These reforms would go a long way to making the ITC a less attractive venue for NPEs seeking to force settlements and separate litigation. Members of the subcommittee, the ITC needs reform. This is an essential agency that advises the President and Congress on trade issues, but it is being misused by NPEs. This hurts both consumers and manufacturers. In our view, Congress should require the ITC to demonstrate that any exclusion order preventing the importation of a product into the U.S. is in the public interest, but this is not the case today. The Alliance for Automotive Innovation looks forward to working with Congress on meaningful reforms to the ITC. Thank you, and I'm happy to answer any questions.
Thank you. Mr. Corti, you will be the last witness before we break for about 30 minutes total to do 4 votes on the floor. Please proceed.
Thank you, Chairman Issa, Ranking Member Johnson, and distinguished members of the subcommittee. My name is Sam Corti, and I'm a patent attorney with Garmin. Garmin pioneered the GPS industry. Some of you may be familiar with our car navigation devices, smartwatches, and fish finders, but we also make products as diverse as aircraft auto-landing systems and Doppler radars. We're a global company employing over 7,000 people in the United States, including thousands of highly skilled engineers. We have 3 large manufacturing facilities in Florida, Oregon, and Kansas. Intellectual property is very important to Garmin. We hold thousands of patents on our products and are committed to a strong patent system. A balanced patent system is not only necessary, but also a key factor in our ability to grow our U.S. business and employ thousands of Americans. In my testimony, I will address 3 issues. First, the ITC has shifted from its roots as a specialized forum for addressing international trade disputes to a superpowered and super expensive district court accessible to anyone with a patent. Second, ITC 337 investigations often target American manufacturers, impacting the design and manufacture of products within the United States, resulting in a high cost to everyone involved. Third, Garmin, as an American manufacturer, has experienced these effects firsthand and has recommendations for Congress to address these issues. Section 337, dating back to its roots with the Tariff Commission, was never intended to involve routine patent lawsuits. But over the years, through statutory changes by Congress and the ITC's own interpretation of the law, the ITC has become a forum accessible to almost anyone with a patent. In many ways, the ITC is now no different than any federal court, with one critical exception. Exclusion orders, which bar all imports of infringing products, are automatic if the ITC finds a patent violation. District courts, however, only employ the nuclear option of an injunction by carefully weighing equitable factors related to the parties and the public interest. In almost all cases, ITC exclusion orders against losing companies take effect soon after the ITC issues its final determination. Assuming a losing company is going to remain in business, it must either pay whatever ransom is demanded by the patent holder or go through the expense of changing its products. This is all in addition to the costs of defending parallel lawsuits on the exact same technology with the exact same people in federal district court. Our cost to defend an ITC investigation is multiples the cost of defending a case in federal district court, in some cases exceeding $10 million. None of this is lost on those looking to harm U.S. manufacturers. Patent trolls, or non-practicing entities if you prefer, have targeted Garmin at the ITC over basic commodities like computer memory and microprocessors. Because these components are central to Garmin's U.S. product manufacturing process, a loss at the ITC could shutter our critical American factories, unless Garmin, of course, paid whatever ransom was demanded. Congress has many options to address these problems with the ITC. First, Section 337's domestic industry language has confused the ITC and the Federal Circuit since it was last revised by Congress in 1988. Clarifying the language regarding domestic industry, such as by requiring a patent owner to show that it has assisted in bringing a product to market through licensing or other efforts, would ensure that the ITC is not merely functioning as another federal court. Today, a patent owner can fabricate domestic industry by sitting on its patent for decades, suing a manufacturer that independently developed its products, cheaply licensing its patent to the manufacturer it just sued, and then racing to the ITC to file a 337 complaint against the rest of the established industry. This practice should end. Second, Section 337 could also be revised to address automatic exclusion orders by requiring the ITC to engage in a more detailed analysis of the public interest, including weighing the impact of an exclusion order on a U.S. company, American workers, and the public at large. Finally, it's not lost on Garmin that the statutory purpose of the ITC is to protect American domestic industry, companies just like Garmin with factories in places like Florida, Oregon, and Kansas. But the ITC is now routinely used by foreign companies, sometimes funded by their own governments, to disrupt American innovation and production. It is impossible to tell the true party behind an ITC investigation, and the ITC does not ask. This distortion of the ITC's purpose undermines the entire congressional intent behind Section 337. It poses a threat to the ability of American companies to compete on the global stage. Congress is best suited to address this problem. Thank you again for the opportunity to present testimony on this important issue facing American companies. I look forward to your questions.
Thank you. As promised, we'll now take a hopefully very short recess. We stand in recess. hear from Professor Contreras. Yeah, the mic both has to be turned on and held as close as possible. It's more effective that way. Thank you.
There we go. Thank you for that. Mr. Chairman, distinguished members of the committee, my name is George Contreras, and I am a professor of intellectual property law at the University of Utah. So in the years following World War I, European manufacturers were accused of flooding U.S. markets with cheap goods that violated U.S. intellectual property rights. In response, Congress authorized what became the International Trade Commission to investigate unfair acts pertaining to U.S. imports, including the importation of infringing articles. This authority was needed to fill gaps in then existing law. For example, the U.S. Patent Act did not then offer a remedy against the sale of non-infringing products made abroad using processes patented in the U.S., nor could U.S. courts hearing patent cases assert jurisdiction over foreign producers of infringing goods. Today, more than a century later, the world is a different place. The Patent Act has been amended to prohibit the sale of goods made abroad using infringing processes. Likewise, overseas firms routinely establish subsidiaries in the U.S., bringing them squarely within the jurisdiction of the U.S. courts. As a result, in 2022 and 23, only 6% of ITC patent cases lacked a domestic respondent subject to personal jurisdiction in the U.S. So what about the other 94% of ITC patent cases? Ironically, they are brought against domestic companies who offer American consumers lower prices by manufacturing products overseas. They are brought by non-practicing entities seeking to pressure manufacturers to enter into monetary settlements. And most surprisingly, nearly a third of ITC patent cases are brought by foreign companies seeking to prevent U.S. companies from importing their own products for sale to U.S. consumers. So patent asserters will tell you that the ITC is a wonderful thing, that it affords them exclusionary remedies that are no longer available in the courts, that it is fast, that its judges and staff have unprecedented expertise in patent matters. So whatever the merit of these assertions, and some of them are somewhat questionable, they do not avail. Notwithstanding any tactical litigation advantages the ITC may offer to patent holders, there is little justification for the maintenance at an annual taxpayer expense of nearly $40 million of a duplicate patent litigation system in the U.S. And with respect to patent matters, the ITC is duplicative. In the last 2 years, 83% of all ITC patent cases had parallel proceedings in district court, often involving the same parties, the same patents, and the same infringing products. The result is costly and often inconsistent parallel litigation. We have recently seen examples in which patents are found invalid at the ITC and then asserted again in court. We have also seen the ITC extend its reach even beyond the patent statute, blocking the importation of non-infringing goods that might someday be used for infringing purposes. The truth is that the ITC offers patent holders a second bite at the apple, an unprecedented opportunity to prevail in one venue on claims that were rejected in another. This privilege, while understandably attractive to patent holders, is virtually unknown in any other form of litigation, from medical malpractice to breach of contract. So what should be done? Over the years, a range of proposals have been made to rein in the ITC's ever-expanding patent jurisdiction, all to no avail. But this month, in its landmark decision in Loper-Bright versus Raimondo, the Supreme Court issued a clear message to the nation that the power of administrative agencies in the U.S. has gone too far, and that the authority of these agencies must yield to that of our constitutionally empowered courts. As such, the time is ripe for Congress to reconsider the patent jurisdiction of the ITC. A few potential corrective measures might include: 1, restricting ITC actions to parties over which the federal courts lack jurisdiction; 2, narrowing the definition of the U.S. domestic market to exclude patent assertion and licensing by parties that don't actually make or sell products in the U.S.; 3, requiring the ITC to follow judicial precedent when issuing remedies for patent infringement; and 4, enabling the courts to work directly with the Customs and Border Protection Agency to prevent the importation of patent infringing goods, as they already do with products that infringe U.S. copyrights and trademarks. With one or more of these straightforward measures, Congress can correct the ITC's course to focus again on its primary mission of protecting U.S. markets from unfair foreign imports. Thank you for your time.
Thank you, Mr. Doan, Professor Doan.
Chairman Issa, Ranking Member Johnson, and distinguished members of the subcommittee. Thank you for this opportunity to speak with you today about intellectual property litigation before the U.S. International Trade Commission. My name is Michael Doan, and I'm a law professor at the University of Akron School of Law, where I teach intellectual property law, including a course on intellectual property practice at the U.S. International Trade Commission. Before I became an academic, I was a lawyer specializing in ITC litigation and general counsel for a small technology startup company. I have viewed Section 337 investigations for over 30 years from the perspective of a litigator, an in-house counsel, and now as an academic. During that time, Congress strengthened Section 337 to make it an effective tool to address infringement of U.S. intellectual property rights by unfair imports. Congress was particularly concerned with protecting American innovators such as startups, universities, and individual inventors from foreign infringers. Congress should be cautious of proposals to restrict access to relief under Section 337 to ensure that they do not harm this important sector of the United States innovation economy. Small startup companies face many challenges when bringing a new product to market. These include not only creating the patented technology, but also developing a product that embodies the technology, obtaining financing to develop and bring that product to market, creating manufacturing capability, developing a distribution network, and ultimately finding customers. This is all expensive and time-consuming, particularly if the startup company is faced with infringing products, sometimes before it is even able to fully develop and market its own product. Quite frequently, indeed in almost every circumstance, these infringing products are imported into the United States. Section 337 provides startups with the most direct and efficient remedy for this problem. Efforts to limit access to relief under Section 337 will ultimately do more harm than good. Section 337, as has been noted, is a trade remedy statute, not an intellectual property statute, which was designed to address unfair imports and is one of the most effective mechanisms for defending U.S. intellectual property rights from imported infringing products, particularly from China. Section 337 provides many advantages: expert administrative law judges, comparatively expedited proceedings, in-rem jurisdiction, and effective relief. It is perhaps this last advantage, in the form of an exclusion order, that is the most significant. Because of this remedy, Section 337 is frequently the most effective, if not the only option, for addressing two specific challenges that startup companies face. One, patent holdout, and two, knockoff products offered in online marketplaces. Patent holdout is when a large, well-funded infringer uses its size and market dominance to ignore an IPR owner's infringement claims, impose its own product on the market, and usually seek to litigate the IPR owner into oblivion. Without a Section 337 exclusion order, small entities could be forced, in effect, to license their technology to large importers at a reasonable royalty as determined by a district court after years of litigation. As to knockoff products, numerous infringers, usually Chinese, offer their products in large online marketplaces. Infringing goods are offered by countless, difficult-to-identify entities. Such entities, not burdened by the expense of developing technology or creating a new product, simply create a low-quality copy that is sold at a discount. When challenged, such online entities easily disappear and reemerge elsewhere under a different name to continue selling in the online marketplaces. Policing online marketplaces to take down infringing products would be substantially more difficult, if not impossible, without Section 337. It is important that small entities have an avenue through which infringing products can be removed from the marketplace in a more efficient manner. Monetary damages, if they can even be obtained, are certainly important, but the ability to develop and market one's own product free from unfair competition from infringing imported products, particularly for a small startup company, is infinitely more important. When faced with infringing imports, the high cost of potential litigation may effectively deter a small company from seeking to enforce its IP rights, particularly against a well-funded infringer. Section 337 investigations, while also a potentially expensive endeavor, offer an effective and expedited remedy if successful. This is what Section 337 provides. In fact, Congress expressly amended 337 to make this relief more easily available to small innovators. As Senator Frank Lautenberg, one of the drafters of these amendments, noted, smaller businesses should not be denied the right to seek relief merely because they may have made smaller financial investments than large companies in developing or exploiting an intellectual property right. Section 337 provides unique and effective relief against imported infringing products. Any effort to limit access to Section 337 will ultimately negatively impact those that Section 337 was expressly amended to protect and should be carefully considered. Thank you.
Thank you. I want to thank all the witnesses. With that, we're going to go. There's a lot of people who have various other requirements, so I'm going to try to go to people in the order in which they can ask questions, so don't be surprised when it skips around on both sides. With that, we go to the gentleman from Kentucky, Mr. Massey.
I thank the chairman. Ms. Hairston, Mr. Corte, and Professor Contreras, you all mentioned this thing called public interest. Do any of you want to explain to me what public interest is in the context of deciding a patent dispute? Ms. Hairston, what do you mean by public interest, that the ITC should consider public interest?
Thank you for the question, Congressman Massey. We would say that in the public interest means that it is for the 4 factors that have been articulated in the ITC statute in terms of public health and welfare, competitive conditions, and other factors should be considered when looking at the public interest, that it should not be left solely to the ITC to determine that potentially infringing or non-infringing goods would constitute a violation of public interest.
Mr. Corte, how would you describe public interest consideration that you've proposed?
Thank you, Congressman. So public interest should be tied to the statutory purpose of the International Trade Commission, which is to protect the American domestic markets. The ITC should not be taking any action, let alone an exclusion order, if it's damaging American industry. And that should be the sort of analysis the ITC should do under Section 337. That analysis should include what's already in the statute, in addition to other requirements like the impact on American workers, American factories, and the American industry at large.
Ms. Hairston, one of the remedies you said is if there's less than 10% of the product that's infringing or deemed to be infringing, assumed to be infringing, that you should still be able to import that product. Is that true?
Yes, Congressman Massey, that is a number that the 10% threshold is something that we suggested in terms of to invite conversation and dialogue. But yes, the 10% of the overall product is attributable to the allegedly infringing product. We believe an exclusion order should not be issued.
Okay, let me just say something. I'm appalled that you guys are here testifying like this. This is shameless. You're like here trying to divvy up the goods of the American inventor. What you're saying is that if you're only stealing 10% of the product, let us keep importing it. Let us just keep stealing it, as long as the theft is at a low enough level. And then this public interest notion. This is a communist term. What you are saying is it may be in the public interest to let somebody keep infringing. And the Constitution guarantees the right to exclude somebody from infringing. It doesn't say that the government can come in and figure out what a fair price to pay is for that infringement. Yet that is what all 3 of you, even you, Professor, are suggesting with this term, public interest, because we've seen it used in the past. And I am just appalled that you have no shame in saying that you should be able to steal product from an inventor in the United States, have it manufactured overseas in China, import that as a knockoff, and if you're only stealing 10% of the idea. Professor Doan, Professor Contreras suggested, it seemed like that this ITC concept is archaic, that's no longer needed, that's been supplanted by other means. But then I hear you say, well, Congress has actually updated it. Mr. Corte said that the intent of Congress, needs to be clarified. The intent of Congress is in the Constitution. We don't want you stealing things, getting them made overseas, ripping off American inventors, and then bringing it in here and selling cheap knockoffs to Americans. They're faulty. Professor Doan, is the ITC obsolete?
Absolutely not, Congressman. As I said, it was specifically amended for the purpose of at least small innovators in 1988 and 1994 to make it easier for small inventors, universities, to bring these cases. And I think that's an important task of the commission.
Let me give you an example of whose hand's been caught in the cookie jar here. Apple saw this pulse oximeter technology, said, oh, let's put that in an Apple Watch. They stole the idea, stole all the people that developed it from the original company that was making these in the United States, went to China, had this cheap crap made, and tried to bring it in, and the ITC said you're infringing. Are you aware of this case, Professor Dunn?
Yes, sir, I am.
And That seems like that's the way this should work. When you got a big corporation ripping off a smaller corporation and trying to get the crap made over in China instead of made here, doesn't the ITC have a role to play there, Professor Dunn?
I think that is specifically one of the important reasons for the commission, particularly in the circumstance of a small inventor like a small innovation company like Massimo going up against a large importer of product, to be able to, after years of litigation, they've been in litigation for, I believe, almost 10 years in district courts, and the only relief they've been able to obtain is this ITC exclusion order.
Thank you. I yield back.
Thank you. And I would caution all members, if you're going to use acronyms like CRAP, please define what the letters stand for. With that, we recognize the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. Professor Doan, this subcommittee has a keen bipartisan interest in preventing the government of China from stealing U.S. intellectual property. How does the ITC prevent China from ongoing infringement of the property of U.S. inventors, and would weakening the ITC help China import infringing goods into the United States, and if so, why? Or how?
I believe weakening Section 337 would certainly would benefit China in particular. If you look at where the source of most challenged products come from, infringing products, by far, I believe you would find, they come from China. They come in varieties of forms. As I mentioned, all these little companies that come in, not manufacture cheap knockoffs of U.S. products and sell them in online marketplaces and just end up dominating the marketplace. Or in the circumstance of bigger companies that have spent billions of dollars building infrastructure in China to manufacture there rather than manufacturing in the United States. And in that circumstance, a Section 337 exclusion order might be the only way a small company can get any kind of relief after extensive litigation against a large, well-established importer of what is essentially Chinese products.
Professor Doan, we've heard the arguments of some in the room who want to change the ITC, and some in Congress have introduced legislation to amend the domestic industry requirement to make it more difficult to petition the ITC to investigate a trade violation. In your written statement, you wrote that the ITC should not be amended by Congress. Could you explain for us why the ITC is functioning as intended as it is now?
I believe the ITC does it takes its mandate seriously as to meeting the domestic industry requirement. I think that in the face of the criticism, particularly involving alleged patent NPEs, they've taken a lot of steps to try and make sure that there is a substantial domestic industry. In cases involving where the complaint comes in with a weak domestic industry in the complaint, they will frequently place these into what's called a 100-day proceeding to determine whether there is a sufficient domestic industry to go forward. So I think they've put mechanisms in place to try and weed out potentially problematic cases. And also, I think to the extent that there's a claim of a flood of NPEs coming to the commission, I don't think the data has borne that out. There are certainly some that come there, but I think the commission has taken steps in its own review and in use of things like the 100-day proceeding to make sure that cases like that, if it's merited, are weeded out. So I don't think amending the statute would add anything to what the commission has already done to make sure that the statute is not abused.
Thank you. Some have argued that Congress should revise Section 337 to effectively make it harder for U.S. companies to obtain exclusion orders at the ITC for infringement of their patent rights, especially against U.S. companies or other U.S. companies. As you know, since the Supreme Court's 2006 decision in eBay, patent owners have struggled to obtain injunctions in federal district court, with some studies showing a 90% decline in courts granting injunctions in cases where patents were found infringed. What is the difference between patent cases in the ITC and in federal district court, and why are both tracks critical to protecting and incentivizing U.S. innovation?
Well, I think Section 337 is critical because, in large part, because of the remedy it provides. It gives the patent owner the ability to say, no, you cannot use my patent. I can't be forced to license it to you for a monetary award. You have to, I can keep your product out of the United States. The difference between the ITC and district court right now is the fact that to obtain an exclusion order, you do not need to establish injury. And that is there simply for the simple reason that Congress decided that it should be such. Congress expressly removed injury from the statute in 1988 after almost a decade of hearings on it, and because it felt that too many U.S. companies were losing because of requiring them to show injury, and it was felt that infringement of your patent is injury enough. So injury was expressly removed by Congress, which is why eBay does not apply to Section 337 investigations.
Thank you.
Thank you. For the record, the acronym is Chinese ripoff of American products. Just want to make sure that we understand that it was an acronym. And with that, we go to Mr. Fitzgerald.
Mr. Chairman, if I might
Of course.
ask for unanimous consent to enter into the record a letter from Conservatives for Property Rights, a letter from the Council for Innovation Promotion, and also an op-ed in the Hill entitled the, the Unheralded Agency Protecting America's Innovation Edge.
Gladly, without objection, so ordered.
Thank you.
Mr. Fitzgerald.
Thank you, Chairman. Professor Contreras, I introduced a bill, the Prohibiting Adversarial Patents Act. What we were trying to get at is it would prohibit companies on certain national security-related sanctions lists from licensing or asserting their U.S. patents, much as we discussed here this afternoon. To your knowledge, are adversaries like China using forums like ITC to assert U.S. patents that generate revenue in circumvention of U.S. sanctions?
Congressman, I'm not aware of any concerted effort by the Chinese government in that respect. Certainly, companies from many different countries are able to utilize the ITC against U.S. companies and against other foreign companies if they do so through their U.S. subsidiaries, which almost every foreign company of any size has today, which does make the ITC a forum available to foreign companies controlled by whoever to take advantage of U.S. manufacturers.
Right, and I don't think we're concerned about some of our friends, but adversaries like China using patent assertion entities to bring infringement suits that generate revenue in circumvention of U.S. sanctions. So, is there anybody out there that they've already demonstrated that they are moving in that direction? I guess is maybe a more a broader way of asking the question. Do you see any of this activity?
I'm not aware of the I'm not aware of a specific national security type of circumvention that's going on at the ITC. My other co-panelists maybe.
Okay, Mr. Corte, please explain kind of briefly how ITC rules of procedure differ from U.S. district courts and why they often lead to higher costs for litigation, right?
Yes, thank you, Congressman, for the question. So there's, I think, two main areas where ITC procedure drives up cost. First, in U.S. district court judges often manage their docket through motion practice, motion to dismisses, summary judgment motions. These motions before a trial often resolve the case or lead to a settlement. Right. At the ITC, typically in a hearing, none of these motions are decided until the morning before the trial. So very few ITC investigations settle before the trial. The ITC noticed this in their last budget request, that they have increased workload because almost no ITC 337 investigations are settling. That drives up cost because every case is going to trial. The second main way that ITC cases drive up costs is the exclusion order. If you are a company either making a product in the United States or importing a product, you have to prepare in advance for that exclusion order in the event that you lose by designing your products, by changing your product supply lines, by changing your inventory levels. That all adds incredible cost on top of the standard cost we would face in a parallel lawsuit in federal district court.
Yeah, so ITC litigation, kind of, the costs associated with it, which is probably difficult to put a hard number on. But I mean, there's so many different steps in that suit that, you know, you're engaged on a regular basis. I'm sure the bills are just astronomical after a while for somebody involved in this, right?
Yes, I mean, there are multiples, 2, 3, 4 times the cost of a patent lawsuit in federal court, where those lawsuits are already one of the most expensive activities on earth. So it's, in some years, our ITC investigation defense costs are by far the biggest line item on our legal budget globally.
Just real quick, Professor Contreras, when an entity brings a complaint to the ITC under Section 337, are they required, do they have to disclose who is funding that complaint? Is that something that's disclosed along the way?
No, they don't. There's a lot of ambiguity around who is behind some of these entities, many of which are names that you wouldn't recognize at all. Their possibly sole purpose is bringing these actions.
And because of the lack of disclosure, there's some risks there, right? I'm sure.
Absolutely, absolutely. It could go back to the question that you asked previously. It could be a pure corporate maneuver. It could be a governmental maneuver. We just don't know.
Yeah. Thank you. I yield back, Chairman.
Thank the gentleman. We now go to the gentlelady from North Carolina, Ms. Ross.
Thank you, Mr. Chairman and Mr. Ranking Member, for holding this hearing. Just for context, I represent the Research Triangle in North Carolina. We don't have as many great big patent holders, but we have a lot of innovators, small startups, and then of course we have North Carolina State University, which has a tremendous number of patents and does some of the most work in the textile industry in the entire country. The ITC is one of the best tools that American innovators have for addressing patent infringement. Even though the ITC hears relatively few patent cases when compared to district courts, it serves a key function for small inventors, startups, and other innovators who find themselves facing patent infringement, of course, from people abroad. Our intellectual property system is not always friendly to patent holders, particularly small patent holders. And it's often far too difficult to obtain an injunction from a district court, and the PTAB is too often misused to the detriment of innovators and small patent holders. The ITC, on the other hand, has a strong record of issuing exclusion orders to protect patent holders from counterfeit and infringing products, even when these patent holders are facing large companies seeking to dominate them through litigation spending. Professor Doan, I frequently hear from patent holders about how the law does not protect their intellectual property. And this is one of the reasons that I'm a sponsor of the Prevail Act, a bill to address the high rate of patent invalidations at PTAB and prevent dual challenges at PTAB and district court. Do you think the fact that the ITC is one of the only venues where patent holders feel that they are treated fairly has contributed to the rise in patent cases that the ITC hears?
Yes, I believe that companies, patent owners come there because they do believe they get a fair shake at the ITC. They get an effective mechanism. They get an efficient mechanism. We've heard mention about how long it takes for a summary determination motion and how they're not granted the ITC. Well, that's in part because the ITC moves so much faster than district court that there's simply no time. By the time you're in trial at the ITC, in a district court, you're just getting started. So, it provides small patent owners an attractive form because it gives them quick, effective, and predictable relief that will remove the product from the marketplace, not just force a license agreement on them.
Thank you. And then I want to follow up on Ranking Member Johnson's question about domestic industry requirements, because as I said, I represent a large university. It has a lot of patents, and those issues are front of mind in my district. How could proposed changes to the domestic industry requirement, such as limiting how patent licensing can satisfy the requirement, harm small investors and patent holders?
I think it would injure them in a number of ways. We know that there's the claim about patent assertion entities, and I think that is, I just think that's not borne out by the data. I think that these changes to domestic industry fall with greater harm on the shoulders of small innovators who are still maybe trying to develop a product, maybe trying to, who've invented something like a university that wants to license, these additional requirements would just simply further burden them as opposed to actually dealing with the purported problem of patent assertion entities. I think it just adds another hoop that these complainants, these patent owners would have to jump through to get any kind of relief for enforcement of their patents.
Thank you very much. I was going to ask another question, but instead I'm going to agree with Congressman Massey, who's since had to leave, and just say that, you know, we've heard some testimony here in favor of weakening the ITC to some degree, and it's troubling to make it harder for a patent owner to stop competitors from bringing infringing products manufactured abroad into the United States. That's on top of the eBay decision, which since 2006 has made it nearly impossible for patent owners to get injunctions in court to protect their property. I don't think that U.S. innovators should be left with no way in court or in the ITC to protect their businesses from infringing products manufactured overseas. And with that, I yield back.
I thank the gentlelady. We now go to the gentleman from California, Mr. Kiley. 5 minutes.
Good morning. I wanted to get a little better sense of, in the circumstance where an exclusion order is issued, what is the sort of typical response by the infringing entity? And Mr. Corte or Ms. Harrison, if you want to weigh in, I mean, is a license usually the result of that? Do they shift their manufacturing domestically? What's the typical response?
Yes, thank you for the question, Congressman. So the typical response is years more of fighting. So once an exclusion order issues, the company that lost probably has already planned for that, as I mentioned earlier, and has products that things don't fall within the scope of that order. So the next step after a loss at the ITC is to go to Customs and Border Protection, and there's months or years of briefing and argument by lawyers at Customs over the scope of the exclusion order and what products it should apply to. So oftentimes there is no license after a loss at the ITC. There's product changes on the market, and then more fighting at Customs and eventually at the Federal Circuit over what the scope of an exclusion order might actually be.
Well, that part of it seems, problematic to me, and maybe everyone, both sides would agree on that. Professor Doan, what do you think about this issue of fighting it with Customs for years? Is that beneficial to the system?
Well, I don't know about how much fighting there is, but with Customs, I do know that respondents that have lost do try to redesign their products, which, by the way, is kind of the point of a patent, is that if you infringe it, the idea for the patent is that you will then try to design around it and thus advance technology even further by coming up with something different. And the Commission does, in fact, provide respondents with the opportunity to present redesigns to the Commission as well, either during the course of an investigation, if they can get them in on time, or in an advisory opinion proceeding at the Commission. You can say, Commission, I want to import my new product. Here's why I think it doesn't infringe. Will you give me permission? The Commission can then say yes or no. And if you win, then you are free to import. You don't even have to talk to Customs. It has been blessed by the Commission.
Right. So maybe that's an area where we could focus on reform as well, is sort of streamlining that process so that it would at least set the stage for a better negotiation over a license, or let folks know what kind of alternatives are available to them. Also, when it comes to the consideration of the public interest, I guess, Professor Doan, this would be a good question for you. Do you know in what % of cases an exclusion order is not issued based upon the public interest factors, roughly?
Well, I can tell you the number, if the question is the number that have been denied because of a public interest consideration, I believe there's been actually very few, maybe 4 or 5. But the commission always does take, particularly in the last 10 to 20 years, has taken public interest not to deny relief, but to modify the scope of relief. They consider it and how they draft the exclusion order, whether particular products are covered, whether to grandfather in already imported products or new products. They do take public interest into consideration to make sure that that there is no harm. For example, this is a trade secret case, not a patent infringement case, but there was a case in which it was found that batteries for electric cars were going to be excluded because they were being produced after theft of trade secrets. But the commission modified its exclusion order, giving American car companies the opportunity several months before the exclusion order would go into force to allow them to switch to and design in other types of batteries into their cars so that they wouldn't be using an infringing battery.
So what do you make of this notion that these proceedings are duplicative because you might have parallel litigation going on in U.S. courts? Is there any validity to that? And from my perspective, it seems that if you're importing a product that may be infringing, then maybe that situation we should have more scrutiny and perhaps the additional remedy than an exclusion order, which we don't really have now in the U.S. system. What do you make of that argument?
Well, it certainly is the case that one can file a district court complaint with a Section 337 complaint. In fact, I would say it's probably more common than not that that is done, largely because the ITC does not have the authority to give money damages. So if you do actually want to get compensation for past infringement, you do have to go to district court to get that. The exclusion order is prospective going forward and removes the product from the market. But there is 28 U.S.C. 1659, I believe is the number, which gives if you are a respondent in an ITC case and a defendant in a district court case, you are automatically entitled to a stay of the district court case until the ITC litigation is completely concluded, including all the way through appeal. So you're not facing two trials at once unless you choose to. You can decide to waive that right, but the statute gives a respondent in that circumstance an absolute right to stay the district court action.
Thank you. Well, I think that there are a number of opportunities for reform to make this process work better, but I think in the process we need to make sure that we're not in any way making it easier for China to infringe on American intellectual property, which seems to be a huge risk here, and also need to be mindful of the impact that weakening the availability of exclusion orders would have on innovation in this country, and particularly smaller innovators. So I thank the chair for holding this hearing, and I think there's a lot we can work on this going forward. I yield back.
I thank the gentleman. We now go to the gentlelady from San Jose, Ms. Lofgren.
Thanks very much, Mr. Chairman. Standard essential patents, those are SEPs, Mr. Chairman, for the acronyms, for many products comply with industry standards, and as you know, owners of SEPs agree to license these patents on fair, reasonable, and non-discriminatory terms. That's FRAND, Mr. Chairman, the acronym, to ensure that the technology is accessible. At the same time, the ITC can issue exclusion orders to stop the import of products that infringe on patents. However, these orders can be disruptive, especially when it comes to SEPs, because they could block the import of widely used products impacting businesses and consumers. I'm wondering if each one of you have an opinion on these two questions. First, the issue of monetary remedies versus exclusion orders. Considering the potential disruption of exclusion orders, do you believe that monetary remedies should be the first option, with exclusion orders reserved only for the most severe cases when SEPs in FRAND is involved? And secondly, given that commitment to license on fair terms, should the ITC avoid issuing exclusion orders when they conflict with FRAND commitments? How should we handle these situations to balance the needs of patent holders and their rights with those of the broader market? Anybody have an opinion on those two questions?
Thank you for the question, Congresswoman. With regards to monetary remedies versus exclusion orders, our position is that If there is actual infringement, that the first option should be those monetary damages and potential royalties, particularly as it relates to standard essential patents. They are licensed largely with the intent to monetize the IP, the intellectual property, and therefore we don't think that an exclusion order is appropriate. With regards to fair, reasonable, and non-discriminatory terms, we don't think that the ITC should be granting exclusion orders. We think that injunctive relief is not appropriate in that context because of the FRAND commitment that the SEP patent holders have made to license to all willing implementers.
Yes.
Yes, thank you for the question. As you know, undoubtedly, in 2013, U.S. Trade Representative Froman, representing the administration, issued the last disapproval of an ITC exclusion order that had been issued to Samsung against Apple, precisely because it involved standards essential patents. And Trade Representative Froman was very clear in his explanation of the disapproval that standards essential patents and standardized products are important for the U.S. economy, for U.S. producers, and to block the importation of products on the basis of standards essential patent was a very significant matter, and that the ITC had not adequately developed the record in terms of FRAND and standards essential patents in that particular case. And to its credit, the ITC has modified its procedures in the intervening 11 years so that there is a much more detailed record developed around SEPs, and the ITC has not issued any exclusion order against a product by virtue of infringing standards essential patents. And I think that's absolutely the right approach to take. When a company is involved in the standardization process, it makes a commitment of binding contractual commitment to the standards body that it will grant licenses of its patents on fair, reasonable, non-discriminatory terms. That means it agrees that if others are going to use its patents, it will accept a monetary royalty. And as long as a company is willing to pay that reasonable royalty, there's really no cause for an exclusion order or an injunction in court either. And so the only question is how much money that reasonable royalty ought to be, and that's a question that the courts will decide. So, so I think that absolutely the ITC should stay away from exclusion orders in the FRAND context.
As Professor Contreras pointed out, the Commission has developed a procedure to develop record on SEP and to determine whether an exclusion order might be necessary. I think that the availability of an exclusion order, the threat of an exclusion order, needs to stay in place even for a potential SEP to avoid the problem of holdout, of companies that say, well, yeah, you haven't offered me good enough FRAND terms, so I'm not going to license, and I'm going to keep going infringing because you can't make me stop. And ultimately, I think that the threat of the exclusion order is beneficial in that ultimately it might force the end of patent holdout in the case of an SEP.
I see my time is just about up, Mr. Chairman, so I yield back. Thank you all for your testimony today.
I'll thank the ladies so much. I now ask unanimous consent that two pieces of litigation history be placed in the record. One is Codalarm versus Direct Electronics, ED, Michigan, 1996. The other is Codalarm Plaintiff versus Direct Electronics, Defendant, Codalarm Plaintiff v. Magnadyne Corporation, Defendant. One is an ITC hearing or process, and the other is an Article III court in Michigan. Since no one else is here, I'll now recognize myself. I put those in the record because those are my cases. I was a defendant. The ITC very appropriately found that the accuser had unclean hands and, in fact, did not have a valid patent, but in fact was asserting a patent that they had applied for after a vendor gave them not only the idea, but the chip. The ITC, for the first time that I know of, refused a dismissal by the plaintiff, continued the case, and the plaintiff then said, that's great, you made your decision on summary judgment to find my patent invalid, but I'm going to continue in Article 3, where we continued in Article 3, ultimately having it decided twice at the Fed Circuit, once sustaining the ITC, once opposing the defendant's plea that his patent in Article 3 was valid. All of that goes to say that my experience with the ITC, although quick and expensive, in fact, was fair. Now the question is, for all of you, and I'll start with Professor Doan, do you believe that the ITC is appropriate, for example, when Broadcom and Qualcomm, two very large multi-billion-dollar companies, face each other over a portion of their intellectual property, and they are simultaneously an Article 3 case? Yes or no, please?
Yes.
Professor Contreras?
No.
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 So this doesn't surprise me. What does surprise me is that much of the discussion today has been about small entities, large entities, and so on. So I'm going to go into a couple of areas that were brought up and try to tie together some of the testimony today. SEPs, Professor Doan, they exist to collect revenue. Your belief is that even though their attempt is to collect revenue, that injunctive or exclusion should still be granted as a leverage tool to get them not to be holdouts, or, in other words, not to assert their full rights in Article 3 where they might prevail. Is that correct?
I'm saying, were you saying SEPs or
An SEP, a potential infringer of a standard essential patent.
I think
You're
that-
saying it should still be exploited and an exclusion should still be granted in the ITC?
I think the availability of an exclusion order should be an option in cases where there has been holdout. I think I would hope that.
I got you. I just want to make sure. So for the other three, because I'm suspecting a different answer, the idea that the ITC is, in Professor Doan's experience of 30 years of practicing, a tool for leverage on what ultimately is a royalty-only product, meaning that a royalty will be granted, it will be paid if the defendant uses, and yet the professor has said that it's an effective, from his litigation history, an effective tool. Would you, A, agree it's an effective tool, and B, do you believe it should be a tool essentially used as a hammer to predetermine the outcome of an Article 3 case? Yes, Professor Contreras.
Yeah, I have been involved in numerous cases where this has been used as a tool and it is effective, but whether it's appropriate is another question. And I think it's not an appropriate tool. Of course, it's a tool that is, favored by patent holders because any tool in the litigation toolkit should be.
There's a reason Broadcom sued Qualcomm in the ITC, is it was a tool available to them, just as Kodak and Apple and lots of other large companies. Mr. Cote, has Garmin used the tool ever? You're an American manufacturer. Have you used it against Asian imports?
No, although we do face our own flood of Asian imports, including from China. We have never used 337 against those imports. We found other recourse, including Article 3 courts, to be much more cost-effective and useful to stem the flood of knockoff products.
Ms. Hairston.
I would agree with Professor Contreras that while it can be a very effective tool, we don't necessarily believe that it's an appropriate tool to use, particularly as it relates to standard essential patents.
Okay, we have another person coming, so I'm going to take a few extra seconds here. One question, I'll start with Professor Contreras. When there is an SEP, for example, we could suggest to the other committee of jurisdiction that a bond in lieu would be a remedy that we could make available to the ITC, not mandate, but make available. Do you think that a bond in lieu where the full cost of the holdout would then be paid in and continue to be paid until the Article 3 case reaches final adjudication? Is that a reasonable alternative to exclusion?
And I would say it's an improvement, and as you undoubtedly know, many European jurisdictions have this idea of a bond in lieu of the injunction. But it's still not really necessary. I mean, we do have Article III courts to adjudicate these matters, and even with a bond, the bond is a significant cost. The small companies are the ones who won't be able to pay the bond. The large companies will.
But Mr. Doan, or Professor Doan, would you say that a bond, a cost, but a cost that is an alternative to exclusion, is at least something that should be a tool in the quiver, if you will, of the ITC?
It is difficult to say without knowing how such a bond would work, but it's certainly something that should be discussed.
Okay. Mr. Hairston, you talked about your various manufacturers, auto manufacturers and so on. Is this something where the idea that you're perfectly willing to pay the damages, capable of paying the damages if a licensee, and we're assuming that we're only talking for a moment about companies which are licensors, in other words, not a company that that demands an exclusive and only has an exclusive. Is that something that you think would improve the treatment at the ITC, assuming they still took the cases?
I think it is something definitely worth exploring. I'd like to take it back to my member companies to discuss, to get more insight and share that with you at a later time.
Thank you. That's what this hearing is for. I now go to the gentleman from Virginia, Mr. Klein.
Thank you, Mr. Chairman. Professor Contreras, would you agree that there's a rising trend in abusive investor-funded patent litigation in legal venues across the U.S., including at the ITC?
There's certainly a trend in investor-funded litigation. Much of this investor-funded litigation is for NPE litigation, both in the district courts and definitely at the ITC.
In fact, increasingly, shell companies and other intermediaries conceal the involvement of parties, often foreign, including sovereign wealth funds, hedge funds, other opaque entities in patent litigation against U.S. companies.
This is an issue across the board in patent litigation, yes.
Do these shell companies target critical manufacturers and industries which could disrupt fragile supply chains and undermine the industries and companies that are vital to America's national and economic security?
That is certainly what happens.
Does Section 337 currently require the disclosure of who is funding the complaint?
No.
Okay. So be accurate to say that absent adequate transparency and the disclosure of the real parties in interest to these ITC cases, the extent of this harm will remain unknown to the U.S. public and to the government.
That's correct. We just don't know.
Would it also be accurate to say that the lack of routine disclosure of the real parties in interest raises serious concerns when determining whether ethical conflicts exist during ITC proceedings?
This is a concern as well, yes. There's really no reason that there shouldn't be full transparency.
I'm pleased that as a member of the Appropriations Committee during the FY24 and 25 cycles, I was successful in including report language in the CJS bill to essentially articulate what you just confirmed and direct the ITC to consider implementing a standing rule that would require each party to disclose the real parties in interest in all Section 337 litigation at the ITC. This is a temporary victory, but it seems that legislation is necessary to ensure that the disclosure of real parties is in interest. Would you agree?
I would agree.
Okay. Well, I thank you for that, Mr. Chairman.
With that, the gentleman yield?
Yes, happy to yield.
Let me ask a question. The reverse of the complaint about eBay that I've been hearing here today, and I'll start with Professor Doan. If an Article III court were to find infringement and the ITC then was empowered, essentially sua sponte, to issue an exclusion based on that decision, notwithstanding eBay, would you support that?
I don't know if I need to support that. I think that's how that would work. I think if
well, even if you haven't made haven't been in the ITC, you simply go to the ITC.
If you have a finding of infringement and you then say, well, they're continuing to import even though I have this finding of infringement against them, I think the commission would be bound by the district court's order, finding of infringement, and to the extent there was validity findings, they'd be bound by those as well. And if the other requirements of 337 were met, then certainly they can issue an exclusion order.
So as a summary decision, Professor Contreras, do you agree that notwithstanding the eBay decision, that a federal court that finds infringement and the ITC finds that the product is still being imported, that an exclusion would be something it could grant in a matter of basically days, not a year?
Yes, that is certainly possible. I mean, it's really Customs and Border Protection that is the
They implement.
relevant implementer here. The ITC
But the ITC
really need
could be, this could be an effective power that would dissuade people from going to the ITC at greater expense, but have everyone recognize that you can't rely on eBay if in fact you're importing. I'm asking because we're looking to try to find common ground here. We are not the committee of primary jurisdiction, even though our Article 3 judges find themselves a little amused that they're stayed while an administrative act that may not be a complete remedy occurs. The other two witnesses, any comment on that? You certainly have Article 3 against infringers.
Yes, certainly, and my only reservation with that process is the ITC's statutory requirement is to protect American domestic industry. So before it takes any action, including an exclusion order, it should be looking to see if that exclusion order is in furtherance of that American domestic industry.
Sure, that's why I said days, not hours.
Yes.
How about for the auto industry? Is this something that would be comfortable as a possibility that the ITC would act in an expeditious manner, but after an Article 3 case was adjudicated?
I think that certainly sounds reasonable. I would agree with Mr. Cortes' reservations, but I think that's something that could be potentially workable.
Okay. Then having no other questioners, I'm just going to quickly give you the synopsis. I'll give you a written copy of questions from the other Committee of Jurisdiction, Ways and Means. They were particularly interested in activities that are on the order of the Chinese government, the Chinese Communist Party. And one question was, how might Section 337 be improved to be a more powerful tool to block imports of products that infringe U.S. patents, misappropriate U.S. trade secrets, and otherwise undermine intellectual property of Americans? So as you can see, their question is, how do we make it stronger? Professor Doan, I think you'll enjoy helping us answer that. The next one is, to the extent that some witnesses call for reforms related to 337 litigation, will these reforms be helpful to better hold China accountable for abuse of intellectual property? And I would assume that's both directions, infringing and perhaps the patent troll process. And then, to the extent that some of the witnesses call for reforms related to 337 litigation, to what extent would the problems you identified be solved by administrative action by the ITC rather than a statutory change? In other words, can they heal thyself, is, I think, the question. And that is an important question that occurs to me, too, that sometimes our hearings provoke changes at agencies. Do you want to make any closing statements?
No, I have none. I'm just ready to get to my next committee.
Seeing that there are not, I would ask in closing, would you all agree, pursuant to our normal closing statement, that there'd be 5 legislative days in which for members of the committee, either that did ask questions or those who weren't able to send you questions for the record in addition to the ones you got from the Ways and Means Committee?
Yes.
Yes.
Yes, thank you.
Yes.
Thank you. And that's actually the only thing I need to ask. So thank you very much again for attending. We will take your additional remarks in addition to questions if you have further thoughts during that same period. Well, 5 days to get it to you and a reasonable time for you to answer. And thank you very much, and we stand adjourned.
brought my company's products to show something that's developed and manufactured entirely in the United States and that faces all kinds of infringing imports, but I just didn't get a chance to bring it out. It never really fit in. So this is what Kent Displays makes.